welcome to today's program, Don't Get Slapped in Family Court, Spotting and Managing SLAPP Issues in Family Law Cases. I'm Ala Policastro, Director of Education and Professional Development at Beverly Hills Bar Association. Today's program is presented by BHBA Family Law Section, which is sponsored by White, Zuckerman, Warsowski, Luna, and Hunt LLP. They provide a wide variety of resources to complete almost any project, large or small. They also provide traditional accounting and tax practice services. We invite you to contact them to discuss your specific accounting needs and learn how they could be of service to you. And now I am delighted to introduce our speaker today, Brendan Begley. He is a certified appellate law specialist and shareholder at Weintraub Tobin, where he spearheads the firm's appeals and writ group. Brandon handles appeals in various practice areas, including family law, anti-SLAPP litigation, employment law, trusts and probate litigation, commercial litigation, civil rights law, and other various areas. He frequently tops best lawyer lists and is a frequent speaker and contributor on topics related to appellate practice and labor and employment. We can't wait to hear what he has to share with us today, so I'm going to turn this over to him.
Thank you so much for the kind introduction, and thank you all for attending my seminar today. If it wasn't for that generous introduction, you might think that you tuned into Conan O'Brien's podcast about how he's going to try out for a science fiction film. But no, this is indeed Don't Get Slapped in Family Court, and I want to help you all be able to spot anti-SLAPP issues that have been creeping into all kinds of different areas of law, not just civil cases, but probate, employment, and now even in family law. We're seeing it in family law. So you don't want to find out about this after you get hit with an anti-SLAPP motion. Before we get started, though, I have to do the standard disclaimer. I'm going to give you guys a lot of information about this, and then we're going to do some hypotheticals. And in between the two, I'm happy to try to answer questions on the Q&A. I'll stop and we'll see if there's any questions I can answer. Of course, as you all know from being at these MCLE seminars, I'm not going to be giving you legal advice about a specific case. I'm just going to be trying to answer questions so that we can have a better, grasp of how anti-SLAPP might work. I'm going to treat your questions as hypotheticals. So what will we cover today? Well, we got to start by talking about me. And so let me tell you why I'm excited about anti-SLAPP and have been for about 25 years, and why I think you all should be too. In another lifetime, I was a journalist, a newspaper reporter. We had these stone tablets and we chiseled out things. You don't see too many newspaper reporters anymore. But I was one of them way back in the day, and I wrote some very honest and fair stories about a public entity in particular that wasn't used to any kind of criticism. It was a local fire department. They were trying to make a transition from being an all-volunteer department to a professional department. There were some bumps along the way, and they were used to nothing but positive coverage about how the Dalmatian didn't bark on the fire truck at the 4th of July parade, but behaved itself. And so when I started, writing some stories about some of their spending decisions and some of their personnel decisions, they didn't like it, and they sicked a lawyer on me who went to a law school who taught him that the best lawyers are the ones who know how to yell, insult, and cuss. And if you do these things to people, then you're going to make America's Best Lawyers list every year. And so that's the way he treated me. He threatened me with defamation claims and emotional distress claims, and it kept me up at night. I was really worried about this because, my little newspaper, probably wouldn't have a lot of money to defend me. And if he only sued me and not the newspaper, I was what you call a stringer. They might not have had to have indemnified me like they would a normal employee. So it didn't stop me from writing my stories. A judge I used to clerk for nicknamed me Battlin' Brendan. I've never walked away from a good fight. And so I kept on writing my stories, but I had some sleepless nights, and I had to make sure that my sources were corroborated, and I didn't misspell anything in my story. And I wrote some good stories as a result, some really outstanding stories, and he never sued me. But after I got out of law school and started practicing, the anti-SLAPP statute had been around, but it didn't have the teeth it had. It just got these teeth that it has today. And I discovered it, and I thought, you know what? If that anti-SLAPP statute was around when I was a newspaper reporter, I would have slept easily every night. I would have told that lawyer, go ahead and sue me, because you're only suing me to shut me up, not because I said anything wrong. And I'm going to hire some lawyer like me in the future who's going to file an anti-SLAPP motion. and is not only going to freeze discovery so you can't run up a big old bill on me, but it's also going to force you to prove your case at a very early stage without the benefit of discovery. And if you can't do that, you're going to pay my attorney's fees. And so, listen, I think anti-SLAPP is great. Some people have some, reservations about it, and we could have a debate about, pluses and minuses, like everything. There are some problems with it. But enough about me. Let's talk about you. What do you think about not only that I did this as a journalist, but then because I got interested in anti-SLAPP, I expanded it to employment law. And so there's a published case out there, Virgos v. McNeil, and that was a civil rights employment case. And I want to say, among the first to find a way to use anti-SLAPP protection in an employment litigation case. Now, since then, it's really spread to lots of other areas. So what we're going to cover, other than me, we're going to focus on how to recognize claims that could get you either in trouble or give you an opportunity to file an anti-SLAPP motion. And so there's two reasons we're going to do that. You want to avoid pleading a claim that might get you into trouble. And you also want to be able to know how to attack a claim that might lead to really great anti-SLAPP remedies. And because we're talking about things that come in two, I'm going to tell you right now, anti-SLAPP has two prongs. The first prong, the first step, is to figure out if the claim asserted against your client is protected under the anti-SLAPP statute. And we're going to talk a lot about what that means, but that's only the first step. A lot of people think if it's protected, that's the end of the story. The claim is going to get thrown out, but no, that's just step one. Prong one does the claim arise from protected activity? If it does, all it does is shift the burden to the plaintiff, or in a family law case, the petitioner, to show that he or she has a likelihood of success on the claim. And, that's not a hard thing to do. And so I see anti-SLAPP as kind of a heightened pleading standard. You might remember, for fraud, you have to plead with specificity. Well, if you're going to file a lawsuit against somebody that challenges their free speech and petitioning activities, you should have to do a little more than just make the allegation and then run up their bill for discovery. You should be able to show that your case has some minimal merit before it can proceed. And that's all an anti-SLAPP motion does. That's the way it's supposed to work. So what we won't cover, I'm not going to get into a detailed discussion about whether or not it's good or bad policy. If any of you have questions about that, the whatabouts, listen, I'd love to talk about anti-SLAPP. Give me a call. You won't even have to buy me a drink. I will talk about why I think it's still good if you want to engage in a discussion about that. I'm happy to do it, but not during this webinar. And we're not going to do a detailed analysis of SLAPP exceptions. They're out there. It's in section 425.17 of the Code of Civil Procedure, the very next statute after the anti-SLAPP statute. There are some exceptions. You need to know about them, but that'd be a whole seminar in itself to talk about what the exceptions are. Just take a look at them if you find yourself maybe getting close to an anti-SLAPP case. We're not going to do a detailed exploration of slapbacks, but I do feel obligated to at least tell you what they are. They're outlined in the statute after the exception, section 425.18 of the Code of Civil Procedure. A slapback works like this. If I sue you, if I file a SLAPP against you, a strategic lawsuit against public participation, and it's meritless, and you file a SLAPP, anti-SLAPP motion, and you get my claim thrown out, well, then there's that. And so you're going to recover your attorney fees. But you know what you're not going to recover is your emotional distress and those kind of damages. And you're not going to get punitive damages against me. You're only going to get your attorney fees. Well, you might therefore also have a malicious prosecution claim against me. I mean, I filed this case against you that got thrown right out on an anti-SLAPP motion. I couldn't even show it had minimal merit, which means it probably didn't have probable cause. And so you can file a malicious prosecution claim against me. And as you're going to see as I talk more about anti-SLAPP, a malicious prosecution claim is per se subject to an anti-SLAPP motion. Anytime anybody files a malicious prosecution claim, it's malpractice, in my opinion, not to file an anti-SLAPP motion to challenge it. So now you file your your malicious prosecution action against me. And guess what I'm going to do? I'm going to file an anti-SLAPP motion. Woo! And then I'm going to subject you to the same treatment as you subjected me. Well, your malicious prosecution is what's called a slapback. That's a slapback. And so You cannot pursue anti-SLAPP remedies the same way in a slapback that you can in the initial case. There are restrictions, it's harder to do. And so you will still have your malicious prosecution claim against me, and I might try to file an anti-SLAPP motion against it, but my anti-SLAPP motion is not going to have all the teeth that yours did. So that's a slapback. So we're not going to talk anymore about that. You just need to know what it is. I'm not going to go into a detailed assessment of claims that don't enjoy prong one protection because they're illegal as a matter of law. I'll just say this much about that topic. If I sue you for defamation or employment discrimination or a domestic violence restraining order, if I sue you for any of these kinds of things, and you file a motion against me in anti-SLAPP, and you say, well, it arises from protected activity. I can't really defend that by saying, no, it's not protected because the conduct was illegal. That's a step two concern. I got to do that at step two. It doesn't defeat the claim at step one. So, except in a very rare exception that's outlined in this California Supreme Court case, Flatley v. Morrow, where if the activity that's supposedly protected is illegal as a matter of law on its face, without any declarations to prove the bad stuff happened, if you can just look at it and you can see this is extortionate on its face, and therefore it's not protected. So extortion is usually the exception, but I could spend an hour talking about that one case alone and how it works. So we're not going to get a lot of detail about that. Again, my point is to help you all recognize anti-SLAPP issues so you don't file a petition that can be attacked by an anti-SLAPP motion, or so that if you get hit with a petition that can, what to look for to figure out what else you have to find out to pursue that anti-SLAPP motion. We're also not going to do a detailed coverage of anti-SLAPP motions in federal court. I'm just going to tell you they're out there. You can file them in federal court, but it's very rare for a family law case to wind up there. So you probably don't need to worry about it. Just know it doesn't work exactly the same as it does in state court. Okay, what else we won't cover? I'm not going to go into detailed how-tos about how to file the motion. I'm not going to do detailed what to do's if you get hit with a motion. I will say if you get hit with an anti-SLAPP motion, right away you should be thinking about, how am I going to get discovery? I'm going to have to file an ex parte application to get leave to do discovery. You can't wait to file your opposition papers and ask for it. You have to do things double fast in that regard. I'm not going to do detailed whatabouts in connection with attorney fees, although attorney fees are an important issue here. You're going to see it is the 800-pound gorilla in many of these cases. And I'm not going to cover detailed oh no's about the discovery freeze or the immediate right to appeal or how to preserve or overcome or execute or defend against any of these things. I am going to say some things about it just so you can understand the gravity of what an anti-SLAPP motion can bring. All right, so why do we have anti-SLAPP law? I mean, it just to make things more complicated, right? It might seem that way, but no. It sort of came out of, the kind of textbook example of anti-SLAPP, and why we have it is you have a big box store that's going to build, one of their, big box stores in your neighborhood. And, you run a small business and they're going to run you out of business, and your neighbor's an environmentalist and is concerned about, these animals are going to be crossing the road. They're already on the endangered species list. They're going to get run over by all these crazed shoppers running to the big box store to get the bargains. And then you got other people who are just concerned about the routine traffic pollution, noise pollution, those kinds of things. And so, you get together with them and you start circulating the petition because you want to tell the city council, the zoning commission, or the board of supervisors they shouldn't greenlight this project. It's not going to be good for your community. Let them build it somewhere else, and people can drive 10 miles away to get there, but don't build it right here. And the big box store decides, you know what, you're interfering with us because you're making it harder for us to open our operation. You've not really defamed them. You've not really committed the tort of, interference with prospective economic advantage or, contractual relations. You've not committed the tort of infliction of emotional distress, because what you're doing is not outrageous. In fact, it's constitutionally protected. But if there was no anti-SLAPP protection, you'd have to march through discovery up to a summary judgment motion probably to show that your petitioning activity is constitutionally protected, and that's pretty expensive. And all you're trying to do is protect your neighborhood. And when you realize you're going to have to spend 20, 50, $100,000 defending yourself against this frankly meritless case, this strategic lawsuit against public participation, you're going to give up the fight. And so right here in the statute, 425.16A, it doesn't say all that about big box stores, but it says there's been a disturbing increase in lawsuits that are brought just to chill the valid exercise of First Amendment rights. And so when they first passed this law, you know, trial courts were constraining it very, very narrowly. Well, worse than trial courts, appellate courts were. The Court of Appeal in various districts was constraining it very narrowly and making it really hard to file these anti-SLAPP motions. And so the legislature amended it to include this highlighted thing. To this end, this section shall be construed broadly. And so it's supposed to be, it's not construed as broadly as it should be, in my opinion, but we'll talk about that in a little bit. That's kind of why we have it there. We have anti-SLAPP though, so that people can engage in these protected activities without having to spend loads of money in order to do it. And so, you know, if an anti-SLAPP motion freezes discovery so that we can figure out if this case has minimal merit, if it should proceed, and if not, make that plaintiff or petitioner pay the other side's attorney fees for having to file the anti-SLAPP motion and get rid of this thing so it doesn't clog up the courts and run up, you know, the defendant's bill or the respondent in a family court action. Well, why should you care? I mean, this all sounds like great do-gooder stuff, and you know, but your clients aren't out there circulating petitions, you know, to stop a big box store. So you're a family law lawyer. Why should you care? Well, because if you file a petition that contains, you know, an anti-slappable allegation, you're going to get hit with the discovery freeze, and you know, it's going to not only put a freeze on discovery, but it's going to force you in defending against the anti-SLAPP motion to give the other side the very best evidence you have without them propounding one interrogatory, one document request, or taking one deposition or subpoenaing one third party. They're not going to have to do any of that. They're going to force you to hand over your very best evidence right at the beginning of the case. So even if they don't prevail on the anti-SLAPP motion, they are going to be ahead of you in the discovery, you know, campaign. They're going to get all kinds of stuff from you, and you're not going to get it from them. So, okay, I know in family law there's often not as much discovery as there is in civil action. So I might not have won you over yet. You might not really be alarmed about you have to understand anti-SLAPP to be a really great family law practitioner. Well, there's also the moving party is going to recover his or her attorney fees. If they beat you on anti-SLAPP motion, they're going to get some real money. A standard amount is going to be, I'd say, between $30,000 and $60,000. I only saw one case that I know of where it was under $10,000. Normally in today's, you know, well, with the inflation, you know, that we all have for who knows how long, it's going to be probably $30,000 to $60,000. I'd shrug my shoulders and say it sounds about right. I'll tell you what, there's published decisions that go well into the six figures. They award anti-SLAPP people who move for anti-SLAPP relief and get it. There's cases, appellate cases that published appellate cases that affirm recoveries well over the century mark, well over $100,000. All right, so your client is not going to be happy if you draft a petition that subjects him or her to an anti-SLAPP motion. And really, I would never want to be the lawyer explaining to my client, well, not only are they going to strike that allegation, but you're going to have to pay your arch enemies, you know, your wayward ex-spouse's attorney fees, not just mine, but theirs too. Your clients are not going to be happy about this. On the other hand, if you get hit with an anti-SLAPP motion and you can show it's frivolous and you defeat the anti-SLAPP motion, you can get a recovery of attorney fees too. That's going to be a little bit harder to do. It can be done. I've seen it done. But if you're the non-moving party on the anti-SLAPP motion, it's harder to get fees. But if you're the moving party on the anti-SLAPP motion and you prevail, you're going to be getting a whole lot of money back and your client is going to be thrilled. All right, well, you know, to get those fees, it's probably going to depend, for the non-moving party, it's going to depend a lot more on prong one. You know, the party who filed the anti-SLAPP motion, you're going to have to be able to show that they couldn't even get past prong one to show that it was protected activity. If they get past prong one and lose at prong two, you're probably not going to recover your attorney fees because prong two is your burden. If you filed the petition that gets challenged, somebody files an anti-SLAPP motion against you and they get past prong one, at prong two, the burden shifts to you to show a likelihood of success. And so if you show a likelihood of success, that doesn't mean that their motion was frivolous because they achieved they're a burden on their motion. So it's very unlikely to get that. But there are published cases that say you get them, and both of them are prong one cases. Let's see here. All right, you still might not care. Okay, you're like, yeah, attorney fees. I only take wealthy clients, and so they can afford to pay it, and they always want to be aggressive, so they don't mind the discovery fees, and they don't mind the attorney fees. Why should I care about anti-SLAPP? Well, here's the last reason. Because if, somebody files an anti-SLAPP motion, whether it gets granted or denied, there is an immediate right to appeal. Either party can appeal. Whoever wasn't happy with the outcome can appeal. And so it doesn't sound that bad. Well, not only is discovery going to remain frozen during the pendency of the appeal, and being an appellate specialist, I can tell you that appeal is going to take every bit of a year and a half, maybe 2 years, maybe even a little longer. But well, I should say every bit of a year and 3 months, more likely a year and a half, maybe even closer to 2 years. And not only is discovery going to remain frozen, but proceedings in the case. I mean, if your family law judge thinks that there's any overlap between other things going on and the anti-SLAPP claim, everything's going to stay frozen. Now, change circumstances and this and that. Sometimes there's other things you still can be doing. It just depends on what the nature of the claim was that was attacked. But there's going to be a stay in proceedings while that appeal goes on to some extent. And so that might not be, what your client wants. Okay, hopefully I have you all thinking, all right, if I get hit with one of these, space alien anti-SLAPP motions, I'm going to need to know how to deal with it. And so I better be on the lookout for them anyhow. I better be able to at least recognize if there's going to be an anti-SLAPP problem somewhere on either side. And so you want to know the basics of how it works, at least enough to know how to be able to spot an anti-SLAPP issue. So how does it work? Like I told you, there's two prongs. And it's spelled out in section 425.16b, like Brendan. And so number one says if the cause of action is against somebody for doing something that is in furtherance of their First Amendment rights, then the anti-SLAPP motion advances to the next step where the court has to decide if the plaintiff has established that there's a probability of prevailing on the claim. And if I didn't say it already, I'll say it now. That's like a summary judgment standard. I know there's no summary judgment motions in family court, but you all had Civ Pro in law school and you remember summary judgment is like just a triable issue of fact. If one says, it was this day and the other says it's that day, it's a triable issue of fact. We're not going to grant the motion. We're going to let it proceed and we're going to have a bench trial to figure out, was it that day or the other day? All right. In making the determination, though, the court can consider not only the pleadings, but also affidavits and declarations and exhibits that are attached to those things. And so it is like a summary judgment motion. It's not like a demur. It is a summary judgment like motion. And they get decided faster than summary judgment. Summary judgment is now like, 110 days or something like that. Anti-SLAPP, you're going to see it has to move. It's supposed to move along kind of quick. And so the basic logistics is you have to file the anti-SLAPP motion within 60 days of being served with the complaint, is what the statute says, but a complaint, as you're going to see, also means petition. Or, anytime after that, if the court says it's going to give you extra time. 20 years ago when I started doing this, courts were more generous about giving you extra time. Not so much anymore. Listen, try not to avoid, if you have to file an anti-SLAPP motion, try not to miss that 60-day deadline because usually they're going to exercise their discretion and say, no, you missed it and that's it. Now, not only do you have to file it within 60 days, the statute says it's got to be heard within 30 days, not like summary judgment, right? Where you get like 80 or 100 days notice or something like that. You got to do it within 30 days. The court's supposed to hear it within 30 days. But there's a caveat there, unless the docket conditions require a later hearing. They always do these days. For me, anti-SLAPP hearings in the last year or two have been 4 to 6 months out. But you know what? Discovery remains frozen during that whole time. Once you file the motion, discovery is kaput. So again, if discovery is a concern for you, you want to be on the lookout for anti-SLAPP vulnerability. All right, so I told you, uh, the statute uses the word complaint, but it's not confined to complaints. The Court of Appeal has treated this provision expansively, and so it includes petitions. A complaint can include a petition. It can also include a cross complaint, and a plaintiff can be a petitioner. And a defendant can be a cross-defendant and a respondent. So listen, it stretches into probate and family law clearly. It even stretches into arbitration, as this slide indicates. Um, DVRO request. Listen, I'm going to let the cat out of the bag here. You've been wondering, tell me how this applies to family law. I'm kind of getting a picture now, but how is it going to show up in family law? Listen, I think the most common area you're going to see it in family law is in DVRO request, domestic violence restraining order requests, and especially probably renewals for those requests, depending on how the renewal petition is fashioned. It will also show up if you get sued or your client gets sued for things you say or do in connection with the family law action. And listen, that is limited only by your own imagination. I got some hypotheticals here, and it's based on real life stuff. So you'll get to see how creativity, just takes a little creativity to find a way to expand anti-SLAPP into this stuff. So DVRO requests. Well, listen, there's one published opinion that didn't analyze anti-SLAPP coverage, but it said an application for an order under the Domestic Violence Prevention Act is like a civil harassment petition under the, Code of Civil Procedure Section 527.6. And so it's a cause of action that can be subject to, an independent lawsuit. And so another published decision says it also didn't analyze uh, anti-SLAPP coverage, but it reasoned that when a DVRO request is filed in a pending dissolution case, you can file it as a separate action on its own, but if there's already a dissolution action going on, you can file a DVRO request in that action. And so if it's filed in a pending dissolution case, it's a quote unquote motion in that case. Well, Brendan, the guy that looks like Conan O'Brien, told you a complaint is a petition or a cross complaint. Is it also, just a motion? Well, that question is kind of unanswered. There's some reason to think maybe you can argue about that. I think most courts are going to say, yeah, a petition or a request for a DVRO is going to be like a cause of action, and they're going to treat it that way. But there's an argument that some people could make that maybe it's not really a complaint. And so let's explore that for just a minute. There's another published decision that did analyze anti-SLAPP coverage, but not the narrow question about if you file a DVR request in an existing dissolution case, is that just a motion? Unlike if you file it in its own separate case, it's clearly going to be a complaint or a petition. What about that? Well, this case didn't answer that narrow question, but it did clearly say in a published citable decision that DVRO request is subject to an anti-SLAPP motion. It clearly said that. It just didn't analyze this one other question that we're talking about right now. Now, in yet another published decision that also analyzed anti-SLAPP coverage, a different court of appeal held that the anti-SLAPP motion can be filed to challenge a petition for injunctive relief under California's civil harassment statute, but it cannot be filed in response to the TRO, temporary restraining order procedure, in that statute. And the Domestic Violence Prevention Act also has a similar thing where once they file that request, it's like, I don't know if it's actually an ATROS, right, an automatic temporary restraining order, but there is a TRO that comes with that. And so you cannot really use I wouldn't think you can use an anti-SLAPP motion to attack a TRO, but you can use it to attack the whole ultimate request for a longer injunction. And so that's how I interpret it. I want to tell you about a different case also. And this case is kind of, for me, a little bit out from Mars, but it is out there. It's unpublished though, so you cannot cite it. You cannot cite it, and courts cannot rely on it. Trial courts cannot rely on it. Don't even try to cite this case. But it says that a DVRO request is a cause of action that's subject to the anti-SLAPP statute. So far, so good. I think that makes sense in terms of anti-SLAPP logic. And that's regardless of the fact that it was filed as a motion in an existing dissolution action. Remember, I want to repeat, this is an unpublished decision. You can't cite it. But nonetheless, this Court of Appeal affirmed the denial of the anti-SLAPP motion because the anti-SLAPP motion didn't move to strike the DVRO request, but only the DVRO remedies requested therein. Listen, that's going to be a tough argument to make, in my opinion. It's a good thing this opinion is unpublished. I think the California Supreme Court would have throttled that. I don't buy that logic one bit. But nonetheless, you might attempt that pitch. I mean, one court bought it. One court of appeal said that's the case. Now, in mentioning this case, I do want to, if he's out there, Andrew Stein at Hirsch Manis LLP, I want to give him credit for bringing this to my attention. And actually, he's the one that gave me the idea about maybe being able to challenge a DVRO as not a complaint, a DVRO request in an existing case. So my thanks to Andrew. I didn't dream this one up myself, but I was already on the lookout for anti-SLAPP and other kinds of DVRO situations. So I'm glad to know that there's somebody out there like Andrew who thinks about these things like I do and is on the lookout for them. So we're going to talk more in the hypotheticals about DVROs, and you'll hear more from me. And if you have questions about it, let me know. But for now, we're going to move on and we're going to talk about amended complaints. There's a warning I want to tell you about. If you see a petition that has a claim in there that you can attack with an anti-SLAPP motion, you got to do it within that 60 days. Now, if the other side, let's say 50 days later, files an amended petition, that does not restart your deadline. If it has that same allegation in there, your deadline expires 60 days after the original complaint, not 60 days after the amended complaint. So you have to get on that. Now, by contrast, if you have an initial complaint that doesn't have a claim that's, subject to anti-SLAPP coverage, but then you get an amended petition that does have that, the 60 days starts from service of the amended petition. So just be aware of that, trap door. Now, you heard me talk about the two prongs. I'm going to say it again. There's two prongs to anti-SLAPP. The first step decides whether or not the claim arises from protected activity. And then the second step only gets triggered if the party that files the anti-SLAPP motion surmounts that hurdle and shows you're suing me for activities that are protected by the anti-SLAPP statute. And then that shifts the burden to the plaintiff or petitioner in family law cases to show that he or she can achieve a likelihood of success, has a probability of success. And so that's the Supreme Court case, Baral. There's more about Baral I'll tell you about. But first, I want to talk about prong two, which is also says in Baral, like I said, it's like a summary judgment-like procedure. Listen, if the claim has merit, it shouldn't be that hard to sign a declaration creating a tribal issue of fact that shows my claim should proceed. It shouldn't be thrown out at the anti-SLAPP stage. So when I hear people say anti-SLAPP is throwing out too many claims, I feel like, well, it's only thrown out claims that if they were good claims, the lawyer wasn't smart enough to be able to make a tribal issue of fact by having the client sign a declaration. It really shouldn't be that hard to beat prong two if your claim has merit. All right, so what is protected? All right, because I'm here to talk about prong one. So you recognize what's protected. So you know if the petition you're about to file is going to get met with an anti-SLAPP motion, or so that you know if the petition you just got can make you a hero for your client because you can file an anti-SLAPP motion and recover attorney fees from the other side. You need to be able to recognize. And so how do I do that, Brendan? Tell us. You haven't told us. How do we recognize it's anti-SLAPP? Something that's anti-SLAPPable? Well, it's right there in the statute. It's subdivision E, like Edward, of section 425.16. And so it's got four different activities, four different categories of activities that are protected. And the first one is any written or oral statement or writing made before a legislative, executive, or judicial proceeding or other official proceeding authorized by law. If you're about to sue somebody and your recovery from them hinges on them being liable for something they said in court, anti-SLAPP coverage. Okay, so DVRO renewal requests are a good example here. You know what? I want to renew my DVRO. I already got one, but the other side appealed and they said all this nasty stuff about me in the appellate brief. And so I don't think they've learned their lesson. And so I want to renewal. Well, you're suing them for renewal based on what they said in the last appeal. That's probably going to be protected. Also, along those lines, subdivision E2 says any written or oral statement or writing made in connection with an issue that's under consideration by an executive, judicial, legislative, executive, judicial body, or any other official proceeding. So, you know, if you got a DVRO and you want to renew it, and you're renewing it saying, well, my ex is telling our former neighbors that, I made up a bunch of lies when I got the first one. Well, guess what? You know what? He or she is talking about an issue that's under consideration or review by a judicial body, right? That the initial DVRO was under consideration there. And so that's probably going to be protected too, which means, if you file a petition that alleges these things, you're going to be faced with the prong two burden of showing a likelihood of success without the benefit of discovery. All right, a couple other things that are protected too. They're going to come up less frequently, I think, in family law cases, but and going back to the two I just outlined, they've already been in family law cases. There's been anti-SLAPP motions on these things, so I'm not just imagining it. It's happened, and I'm going to tell you more about it when we get into the hypotheticals. But these other two subsections of 425.16E, they are protected activity, but they're probably not as likely to happen in a family law case, but you still need to know a little bit about them. And so I'm just going to cover these really fast. Part 3 and Part 4, they actually overlap, and Part 4 actually overtakes Part 3. Part 3 says any written or oral statement or writing made in a place open to the public or a public forum that's in connection with an issue of public interest. Part 4 says any other conduct, which can also include speech, in furtherance of the exercise of constitutional right of petition or the right of speech in connection with an issue of public interest. So both of them, it's got to be a matter of public interest. Public interest doesn't mean everybody in the United States is concerned about it, or everybody in California, or everybody in Los Angeles, or everybody in Beverly Hills, or everybody in a school district. It can even be, a homeowners association. It doesn't have to be all of them. Public interest can be kind of narrow, but both these prongs say it's got to be a matter of an issue of public interest. Part 3 says it's got to be somewhere open to the public. Part 4 says it doesn't have to be. And I'm going to skip ahead because I want to get to our hypotheticals. I'm just going to tell you right now, it doesn't really have to be in a public forum or a place open to the public. So just take it from me. You don't really need that component. You're still going to have a good anti-SLAPP motion as long as it's a matter of public interest. All right, what is a matter of public interest? What's an issue of public interest? There's a lot of cases that address this. Some of them go different ways. And so you got this one Selig case that says the personal details about a reality star are a matter of public interest. But then you got this other case, Bernstein, that says a defendant's celebrity status on its own is not sufficient to make anything the defendant says or does subject to anti-SLAPP protection. All right, so a little bit of tug there. You got to read a little more to figure out which way it goes. Now, by contrast, this case where, frankly, this company was selling these pills that said they're going to enlarge women's breasts. I took pills when I was 19 or 20. You can tell by my complexion, I don't get very tan, and I know the sun is dangerous for me. I took these pills to make me tan. If these breast enlarging pills work as well as my tan pills, I mean, you're not going to get your money's worth. This would be my prediction. But anyhow, somebody sued this company for false advertisement, and that company filed an anti-SLAPP motion. And the Court of Appeal said a dietary supplement's ability to enlarge women's breasts as an allegedly safer alternative to surgery is not a matter of public concern. So don't anybody misunderstand me who's listening to this. I am not saying the size of women's breasts, whether they're celebrity or not, should be a matter of public interest at all. This is not my point. But my point is there are, as we know, a number of women who do pursue this, visual, if you will. And so they might elect for surgery. They might elect for, this dietary supplement. And if they're considering that, they might want information to know about it. And so it might be a matter of public interest. There's a lot of women out there that might want to know about this. And so I'm not convinced that it's, a safer alternative to a common surgery is less a matter of public interest than a reality star's personal decisions. I'm just not convinced of that. But luckily in family law, I don't think you're going to see subsection 3 and subsection 4 protected activities too commonly. If you do, you're going to have to read up on them. All right. So I already talked about how subsection E4 overtakes E3. And I'll say what is or is not a matter of public interest. The California Supreme Court did try to address it in this filmon.com Inc. case. And don't feel like you have to scribble all these cases that I'm mentioning in the slideshow because they are all in your handouts. I got a little blurb about each one of them in your handouts. If you find yourself in E4 territory where you're trying to figure out if something is a matter of public interest, you're going to want to look at this filmon.com case. I could spend a whole hour talking about that issue alone, so we're just going to kind of move past it, okay? But the case is cited in your handout. Now, what if a complaint alleges, or a petition in your world, what if a complaint or a petition alleges both protected and unprotected activities? Well, the allegations of protected activity are going to be stricken, okay? Unless they support a distinct claim on which the plaintiff has a probability of prevailing. That's going to be very rare. This case, this California Supreme Court case came out and it kind of upended. It used to be you had to get rid of the whole cause of action or the whole claim. But now all you have to do is show that, they can't establish liability based on the one protected activity. And so you're going to get your attorney fees. Some of the cause of action is going to survive, but you as the party that moved for anti-SLAPP relief, you're going to get your attorney fees back, and that's going to demoralize the other side, and it's going to take some of the wind out of their sails. That's been my experience. All right, so well-established claims. Listen, if you see a malicious prosecution claim or an abusive process claim, you should be seeing the Conan O'Brien astronaut, every time you blink your eyes. You should be thinking, this is anti-SLAPP right here. It's going to be malpractice not to file an anti-SLAPP motion, probably. Defamation. Listen, not all defamation claims are, going to be anti-SLAPPable, but a lot of them are. That's a very common area where you see anti-SLAPP, both slander and libel. Interference with contractual relations or prospective economic advantage. Also, a lot of anti-SLAPP stuff in that area. Infliction of emotional distress claims give rise to anti-SLAPP motions quite a bit, but I want you to keep in mind, not prayers for emotional distress damages. It's got to be the IIED or the NIED claim, all right? Negligent or intentional infliction of emotional distress. It's got to be a cause of action, not just you want damages because somebody did something else bad to you. All right, emerging. I already told you, I brought it into the employment world. And there's been some up and down there, but the California Supreme Court said, courts of appeal, it's just like Brendan Begley said it is. So stop saying employment claims aren't covered by anti-SLAPP. They are, if the claim arises from protected activity. Probate petitions to disinherit in accordance with the no contest clause. That's going to trigger anti-SLAPP, scrutiny very, very frequently. That's not so close as other kinds of claims. That's going to be, it's not as per se as malicious prosecution, but in my opinion, it's right up there. There's also other kinds of probate petitions that could trigger it. Courts of appeal have not heeded the construe prong one broadly mandate. It's statutory and by the California Supreme Court. They've published some opinions that I disagree with that say certain kinds of probate petitions are not subject to anti-SLAPP. My prediction is someday the California Supreme Court will take that up and say, you know what, they're wrong. Don't do that anymore. I've seen it in landlord-tenant disputes, and listen, it's here now. It has arrived. It's not, I'm just warning you, it's coming. Family law requests for DVROs and renewals have been hit with anti-SLAPP motions. And also, civil actions against family law litigants or their attorneys, for litigation-related statements or conduct, either during trial or in connection with oftentimes enforcing a family law judgment. You're going to see anti-SLAPP stuff here. There's going to be anti-SLAPP activity. Okay. So listen, the varieties of anti-SLAPP kinds of claims are unlimited, actually limited by only someone's imagination and creativity. And that's because the statute's definitional focus, as the California Supreme Court has said, is not on the form of the plaintiff's cause of action, but the defendant's activity that gives rise to the asserted liability. And if that is protected under anti-SLAPP. Okay. We have some hypotheticals. I'm going to look down at the screen. I see chat, but I don't see Q&A. Let me just see if there's something in chat that I should be looking for. I don't think so. I think it's supposed to be in Q&A. All right. I'm not seeing a question there, so I don't see questions in Q&A, which means I guess everybody is understanding me because I'm explaining things perfectly clearly. So going on that, let's cover some of these hypotheticals so that you can really see where the rubber meets the road. Hypothetical number one, you got sympathetic cohabitator who obtains a 3-year domestic violence restraining order against abusive cohabitator and, of course, abusive appeals. And listen, I get calls like this all the time. I got a restraining order against me, but my evidence was better than theirs. Help me. It's an injustice. Everybody who gets these DVROs on them, they almost all want to try to appeal it. And so in appellate briefs, abusive cohabitator calls sympathetic cohabitator insulting names and insists that sympathetic lied to the trial court. Well, not so shockingly, the Court of Appeal affirms the judgment because it's based on he said, she said, and they defer to the trial court in those contests. Well, so sympathetic later goes back, the 3-year term is running out. So she goes back to renew the DVRO for, however much more time she can get. And she alleges that abusive made uh, sympathetic continue to feel fearful during the 3-year period of the initial DVRO because he called her vicious names and dishonestly questioned her credibility in his appellate briefs. And so my question to you is, should abusive file an anti-SLAPP motion to strike that request for a DVRO renewal? And because I can't really single you out and point at you and ask you or have you raise your hands and take a guess, and it's going to take you a minute to type in the Q&A, I'm just going to skip ahead and answer these hypotheticals. Well, as you've learned from my presentation today, these motions have been used to challenge DVRO requests and successfully. But a renewal request remains untested. I've not seen an appellate decision on that at all, either published or unpublished. I did see a DVRO renewal request where the renewal was 100% based on what the other side said, in an appellate brief or in court in the prior litigation. And that to me is that clears prong one easily. That easily clears prong one, which means even if you beat that anti-SLAPP motion, you cannot recover your attorney fees because the anti-SLAPP motion wasn't frivolous. Okay, so we've learned today, right? A complaint includes a petition, which would certainly include a DVRO that's brought in its own separate action, as this hypothetical was, right? This is a cohabitator, not a spouse. It's a cohabitator. And so this is going to be a separate independent DVRO action. And so that's a petition that's covered by anti-SLAPP. And it's not the form of the cause of action that counts, but the defendant's activity. In this hypo, the plaintiff, the petitioner, alleged that the respondent said these things in court. And so that's clearly prong one. And so, look, even if those things that the abusive said in court were misguided, insulting, dishonest, and it's going to be squarely protected under prong one, I believe. So you turn to prong two, right? Just because it's under prong one, that doesn't mean you lose and you're going to have to pay attorney fees. If you can show a likelihood of succeeding, then you're going to be okay. Well, at prong two, a common argument is privilege. It was privileged. But here, you probably can't assert that privilege. Section 47B says anything you say in court is privileged. Now, there's a caveat to that. There's an exception. It's the divorce proviso, right? And that's 47B1 that says of the civil code. It says, if it's filed in an action for dissolution or legal separation, the privilege doesn't apply. Well, this isn't an action for legal separation or dissolution. This is an independent DVPA action, right? And so the divorce proviso is probably not going to apply, and a privilege probably would. And so I think this would probably be a successful anti-SLAPP motion. A lot of family law judges, though, they're not that familiar with anti-SLAPP. A lot of them are prosecutors and never saw an anti-SLAPP motion before because it's not applicable in any criminal case. So I got to tell you, if you file it and it gets denied by a judge who doesn't know it so much, you might file an appeal. I got to warn you, I'm not trying to discourage you, but I just got to let you know, many courts today still refuse to abide by the mandate that they have to construe anti-SLAPP broadly. And they have gone so far, in my opinion, appellate courts some of them are so craven to shrink the coverage of anti-SLAPP rather than do what the legislature said and construe it broadly, that they'll punish lawyers for all kinds of using any kind of creativity if they can. I cite this case, it's in your brief. It affirmed a sanctions award, an attorney fees award saying that the anti-SLAPP motion was frivolous. They said it was frivolous to contend that a theme park could be considered an artistic work. And I just can't resist saying one thing about that. If you have an idea that you can share with me about how a place where you go to take your kids and it triggers their imagination to imagine some really interesting kinds of things and stuff they read in Disney stories is not artistic. But the United States Supreme Court has said patently offensive pornography is protected as an artistic work, and it triggers your imagination to go in a different direction. Please explain this to me. My phone will be ready to take your call. I want to hear about it. But the point I'm making here is you can be sanctioned for being creative with anti-SLAPP motions if the Court of Appeal thinks it's frivolous, and some courts are maybe a little more likely than we would want to find things frivolous. And so you need to also be aware of this SAV Maiden case that says, courts are naturally wary of anything that might cause a chilling effect on the ability of victims of domestic violence and other abuse to obtain protective relief. Well, so that's a serious public policy. We want these people to be protected. You know what else is a serious public policy? Anti-discrimination in employment and housing. That's a serious public policy. But the California Supreme Court has spanked the Court of Appeal, numerous courts of appeal, who tried to say, no, 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 you can't do this in discrimination claims because that would jeopardize the ability of these plaintiffs to, get rid of discrimination in our state. And the California Supreme Court said in the Wilson case that I cited to you, no, that's the wrong focus. It's not how important the public policy is, it's what are you saying the defendant did? And if you're saying the defendant or the respondent should be liable because they engaged in activities that are protected by anti-SLAPP, guess what? You're subject to anti-SLAPP. All right, hypothetical number 2. Dastardly spouse testifies at a hearing in a divorce action that prim spouse is a skank, right? A skank who is an active member of both Antifa and the Proud Boys and NAMBLA. I won't spell NAMBLA out for all of you, but some of you might be old enough to remember this group. So this is quite an array of organizations to belong to, I got to say. So Dastardly's lawyer, Sharpie Wordsmith, advocates to the family court that Prim should not get custody or unsupervised visitation with the kids for those reasons, these memberships in these crazy organizations. Prim sues both Dastardly and Sharpie for defamation, infliction of emotional distress, interference with prospective economic advantage, because Prim had applied for a job at the courthouse. Dastardly and Sharpie file an anti-SLAPP motion to strike those claims. Will their motion succeed? I won't wait to see what you guess. Let's just cut right to it. This hypo is to remind you there's 2 prongs, right? There's 2 prongs. It's not enough that the activity is protected under prong 1. It also has to be meritless under prong 2 in order for the anti-SLAPP motion to succeed. And so they likely can clear prong 1 because, the allegedly actionable statements were in connection with litigation. That's clear. So due to the divorce proviso, we already talked about that. This is a divorce case, remember. Privilege probably isn't going to have the teeth that it would in a different case at prong 2. All right, so that's going to be out. However, Dastardly might also have a hard time defeating the claim. There's other ways to defeat it. He might say, the membership in the organization is provably false statement. But all Prim has to do is sign a declaration under oath saying, I don't belong to those organizations, and you get past prong 2. Now, on the other hand, there's also some other things. Dastardly may partly prevail on prong 2 because calling her a skank is a non-actionable opinion. And so he cannot get liability. There cannot be liability based on whether or not she's a skank. That's an opinion. And moreover, if Dastardly only has evidence to prove that Prim belongs to 1 or 2 of the organizations, but not all 3, it's possible for Dastardly to prevail partially on the anti-SLAPP motion under Baral, which says, the protected activities, if you can't support them, then out they go, and the party that moved for anti-SLAPP relief gets their attorney fees. Hypothetical number 3. Sensitive spouse and insulting spouse entered a marital settlement agreement that concluded their divorce in 2015. This year, Sensitive petitioned to modify child custody and child support due to changed circumstances, while Insulting filed a counter petition to enforce some provision of the marital settlement agreement. And so Insulting's discovery responses in connection with those competing petitions revealed facts indicating that Insulting may have used misrepresentations to induce Sensitive to enter the MSA in the beginning, back in 2015. And so based on these discovery responses, Sensitive files an amended petition to set aside the MSA under, Family Code Section 2122. Well, Sensitive's amended petition for set aside alleges that the fraud was not discovered until it was revealed in Insulting's recent discovery responses to written discovery. So that's kind of tolling, right? The claim for fraud set aside gets tolled until you discover it, and you didn't discover it until you learned about it in discovery. And so can Insulting file an anti-SLAPP motion to strike sensitive set aside petition? Aha, unfair trick question. Yes, of course, you can always file an anti-SLAPP motion. Even if it's not protected activity, you can still file it. Yeah, the question is, really the better question is whether it would be advisable to file such a motion, because if you can't surmount prong one, there's probably a pretty good chance that you're going to get hit with attorney fees because your anti-SLAPP motion was frivolous. And so that would seem to be an insurmountable obstacle here, because the claim in question was merely triggered by information developed in discovery, and the discovery proceedings themselves are not a fact that must be proven to establish liability. The discovery only goes to the tolling, not the liability. And so, listen, I've not seen this actually analyzed in a published decision, but that's how I would analyze it. In my opinion, that just goes to tolling, not liability. And so, yeah, you got this from discovery. You could have got it from your neighbor too. That's just how you got it for tolling. That's not what gives rise to liability. What gives rise to liability is that the other spouse concealed information and therefore committed a fraud when they induced you to enter the marital settlement agreement. Okay, so the actionable conduct in this hypo is probably not protected, even if it were. Again, you'd have to make sure the anti-SLAPP motion was timely, and then we're on to prong two, right? So let's go to hypothetical number 4. Yeah, you know what? I see a couple questions. Let me stop and look at the questions before we do this. Why wouldn't privilege have the teeth on account of it being in a family law case? Because section 47B1 has the family law proviso that says that statements in a family law action are not privileged like they would be in anything else. How does this jive with Family Code section 271? Sanctioning parties for, yes, great question. Oh, you know what? When I see a case that actually does that, I'll expand this presentation to talk about section 271 of the Family Code, which says that a court can sanction somebody for what? Obstructing or preventing, voluntary resolution. But it's not just in the course of settlement, right? It's frivolous motions and all that stuff. That is litigation abuse, right? And so, yes, I think that 271, a motion for sanctions under section 271 also could possibly be subject to an anti-SLAPP motion, but it's going to depend on what you're saying in there and what you're looking for. Listen, if any of you are really thinking about this seriously, give me a call and we'll talk about it. But if I really go on and on, I'll be thinking all day about this and we won't finish in time. We only have 2 minutes left. Thank you both for the excellent questions, though. I have to get you past the 1 hour mark, so I'm going to do this one more hypo to get you there. And oh, looks like there's one more question. I'd rather answer questions than do hypos. I'm not seeing it though. Nope, no open questions. All right. Last hypo then. Sensitive spouse propounds written discovery. Sound familiar, right? To insulting spouse in a case seeking modification of child custody and a move-away order. Insulting, snarky, and insulting discovery responses deeply hurt sensitive. Based on those snarky and insulting responses, sensitive files a separate lawsuit asserting an infliction of emotional distress claim against insulting and insulting's lawyer, right? Sharpie wordsmith. So sensitive's new lawsuit alleges that reading those snarky insults was the cause of the emotional distress. Can insulting and the attorney Sharpie file an anti-SLAPP motion to strike the emotional distress claim? Yeah, absolutely. Again, you can always file it, but the question is, can you avoid liability for filing a frivolous anti-SLAPP motion? And so how likely is it to succeed? Well, I think the motion here is likely to get past prong 1 and thereby avoid award of sanctions because unlike the previous hypothetical, it's the protected litigation conduct, right? Writing and serving responses to written discovery that actually gives rise to liability. That just doesn't, explain tolling. It gives rise to the liability. I think it remains questionable if allegedly actionable conduct is privileged or unmeritorious for some other reason. Gosh, I thought that would have got us to 130, but it looks like I'm still sitting here at 129. So if you don't mind me going a couple of minutes over, everybody, please forgive me, but I want you to get all the credit you're supposed to. Hypothetical number 5. Nasty spouse engaged in a pattern of severe abuse against innocent spouse that resulted in the San Diego County Superior Court granting innocent's request for a 5-year DVRO. Innocent later moved to Lassen County and petitioned the Lassen County Superior Court, both for a divorce and to renew the DVRO that was about to expire. A few months later, before the hearing to renew the DVRO was to be held, Innocent's attorney did as Innocent instructed and voluntarily withdrew the request to renew the restraining order, given the geographic distance from Nasty. However, Innocent's attorney did so without getting the malicious prosecution release from Nasty, who later sued Innocent and Innocent's attorney, alleging malicious prosecution, abusive process, intentional infliction of emotional distress, all that, based on their request for a new DVRO. Is it slap time yet? Yeah, you bet. Listen, I'm not saying I'm really happy that somebody who might be deserving of a DVRO can get this kind of anti-SLAPP relief, but a malicious prosecution arises from protected activity under the anti-SLAPP statute because really, per se, it involves the filing and prosecution of an underlying lawsuit. And so that's going to be per se protected. The IIED claims also arise from, stuff that's barred by the litigation privilege. So prong 1 and prong 2 are both problematic in this hypothetical. So I hope leaving you with that gives you enough, I don't know, not keep you up at night anxiety, but enough, I guess, concern, not anxiety, to think about, I'm going to be on the lookout for anti-SLAPP stuff from now on as a family law practitioner. I need to know about it because I don't want my client to get hit with it, and I want to give my client anti-SLAPP relief if he or she is entitled to it. With that, we're only 1 minute over. You can read through the rest of the hypotheticals if you want in the handout. All the cases I talked about and the statutes are cited in there. And, the statutes are kind of excerpted, but, the important stuff is in there, the stuff that's important for our purposes today. So I want to thank you very much. With that, I'll conclude. And by all means, any of you have follow-up questions, give me a call or email me. I'll be happy to take some time to talk to you.